The expert witness testimony in this country has contributed to quite a bit of confusion in the courtroom regarding the practitioner's actual duties and responsibilities. And it's led to an attempt to put some uniform recipe into all prescribing, and it's neglected the patients. And so many fallouts have come from that, unintended consequences, and it's time to try to regain some balance by really having another look at the guidelines that are out there, the standards of care, and how medical experts present them in different tribunals.
Well, I think from the perspective of a medical expert, a lot of us don't really know what our roles are. And in my opinion, the role of a medical expert is to forget who hired you and simply answer questions honestly and to the best of your ability. The problem is many experts are hired because they will take gray and turn it into black and white. And everyone in clinical care knows that very rarely is the problem black and white. I think from a precedent standpoint that I've learned from Jennifer is once it's been accepted as kind of a standard, it then becomes things people go back to, and you sometimes have to live with bad science and bad statements. I've often thought that if some of the experts I've seen testify had their charts reviewed, I know some of them would not come up as well as they pretend the defendant should.
I agree with that. I think having seen some of those experts' charts and then listened to their testimony or reviewed the transcripts, they become very subjective in the presentation, and the standard is really more objective, and I think we get lost in that. And I don't think that there's necessarily bad intent for most of the experts, but it is a very difficult process on either side to work with the medical experts and try to make sense out of a field where the rest of the stakeholders still have challenges trying to define boundaries and how you take care of the patient but still accomplish minimizing abuse and diversion and dealing with all those other issues out there regarding chronic opioid therapy.
If I'm asked to help an attorney depose a client or an individual, an expert, I can be certainly an advocate for the person who's hired me. I can take that role. But when we're in the court, I think the challenge is to remember it's not who paid you, it's not who asked you to come. It's the questions you're asked and the information that you share with the trier of fact, with the jury or the judge, and it's based on that I think some of us go astray.
In the courtroom, it is so artificial with the rules of evidence or hearing rules, and the people that are there, other than the prescribing practitioner, none of them have seen the patient, and it makes it particularly challenging, when they look backward and try to apply today's standards to yesterday's boundaries and yesterday's tools, and it just becomes a very unfortunate thing. The courtroom is very artificial when it comes to talking about boundaries, and in the courtroom or hearing room, there's only one person that's normally seen the patient, and that is the practitioner whose conduct is at issue. And that makes it super challenging, and the loss of objectivity is a problem. The boundaries not being well defined, the stakeholders not agreeing on certain points has led to reactionary law and reactionary medicine, and that's not good for anybody.